We have two witnesses. The first witness is before us here in downtown Ottawa, Rajesh Randev, yes, who's an immigration consultant. Welcome to the committee, sir. And by teleconference from British Columbia, Mr. Joe Greenholtz, who is an immigration consultant and adjunct professor in the Department of Educational Studies at the University of British Columbia. He has also served at the Canadian Embassy in Tokyo. Welcome to both of you, and thank you for coming to the committee. Mr. Randev will give you up to 10 minutes to make a presentation to the committee.
Thank you, Mr. Chair. Good evening, Mr. Chair and members of the committee. Thank you for inviting me today. My name is Rajesh Randev, and I am a regulated Canadian immigration consultant and member of ICCRC. Today, I would like to shed light on some of the emerging immigration issues that need to be addressed on priority basis to improve our current immigration system. The discussion topic is the challenges faced by the applicants for temporary resident visas, in particular case of visitor visas, and functioning of overseas visa posts. Later, I would like to put forth some practical solution to the problem faced by the applicant, which will improve our current system. First of all, I would like to discuss the opening remark on the CIC website. It says, visitor visas allow people to stay in Canada temporarily. For tourists, whether you are looking for nightlife in a large cosmopolitan city or vast natural parkland, the country offers something for everyone. True indeed. Our beautiful Canada has a lot to offer with amazing landscape, natural parks, and great tourist attractions. Our people share diverse cultures. Their roots stretch far across the globe. People want to visit Canada for wedding, tourism, ceremonies, funerals, and to connect with their families, but they face high visa rejections. This has discouraged people from applying similar sort of visas for Canada, and they prefer other countries over Canada for travel and pleasure. The recent report in BC Business this year shows a sharp decline in international tourism from the period of 2000 to 2010. According to this report by the Canadian Chamber of Commerce, the contribution of international travels to Canada's total tourism revenue has dropped from 35% in 2000 to only 20% in 2010. And one of the primary reasons of this decline in tourism is the high refusal rate in the visitor visa overseas. And further, the CIC website says, visitor visa allow people to connect with family who had immigrated to Canada. I'm not fully convinced with this statement, since eligible families often face refusals in case of even like funerals in emergency situations. The majority of the immigrants of Indian origins, for example, in Canada, they are from Punjab, and their visa post is Chandigarh. And from Chandigarh, the refusal rate is 53%, and the situation is quite similar in other visa posts. And this actual figure for visitor visa alone are quite shocking, and rejection rates go as high as 80%. I doubt that families can stay connected if majority of the applications are refused with preset refusal grounds. The applicants are not only frustrated because of the rejection, but about the unclear refusal grounds, which sound generic for several rejections. Although every case is unique, the case process in such visa posts are treated with generalized opinion rather than case-by-case analysis. I will brief on two of the numerous cases which reflect the anomalies of our existing system. And 3 years back, Mrs. Kaur was suffering from cancer, and her last wish was to see her mother from India. But unfortunately, her mother's visa was refused, and she died before seeing her mother in Canada. And in another case, Mr. Nbo Chui, the only child and an accounting student in Australia, who was refused twice visitor visa to attend his mother's funeral. His mother was stabbed to death while she was working in a restaurant in Toronto. Chui was not granted visa until this was published in Toronto Star and other medias, and when it was called attention of immigration authorities in Canada. Unfortunately, there are several other unpublished cases that suffer from same kind of problem, where visa posts make cold decision in visa cases. You know, even if the applicant has strong ties with India and if he's financially well-to-do in that country, and the visa is refused, and with the reason that that person won't come back. And in cases where the applicants have already applied for permanent residency for Canada, such as family class, the applicants are denied visitor visa, saying you have dual intent and you will not leave Canada. I would like to say why a person who has applied for permanent residence case would jeopardize his or her chances for permanent residency for the sake of temporary status. Maybe the reason for his temporary visit is to explore Canada and develop social ties and finally settle in Canada. The visa officer, whether in Canada or overseas, do have some guidelines for the government, from the government. However, these guidelines must be reviewed from time to time. When I started providing immigration consultancy the first day and now where I stand, I can distinguish what I have learned with experience and client interactions. The same applies to all professions, including visa officers overseas, who must be trained and be given proper experience to take decisions on something as important as uniting a mother to her child. Now I'm going to present solutions for these problems. My first solution for this problem is there should be a good faith bond. Let's say we have a scenario where there's an applicant overseas and he has weak or strong ties, but he is financially sound. To have an optional good faith bond with the applicants as an assurance to comply with the terms and conditions of their temporary stay in Canada, if asked by the visa officer, applicant may enter into a contracted bond for a certain amount with the visa issuance authority. The good faith bond's value can be determined based on the applicant's financial grounds. The applicant will explore, learn, and visit Canada, and the bond shall stay as collateral for his stay, his or her lawful visit. During 41st Parliamentary Session, Mr. Seborn, Vice President, Operations Branch, CBSA, mentioned in his testimony that the average cost to remove a person varies from $1,500 to anywhere from $50,000, $15,000. Worst case, it can go to up to $15,000. My question is, if we can have a good faith bond from the applicant overseas, that good faith bond, in case that applicant try to violate the terms and conditions in Canada, that good faith bond can be used to remove that person from Canada. And this kind of provision is already being practiced in provincial nominee programs, and in case of detainee, if the refugee detainee is here, then he is released on certain conditions by putting bond. And in certain provincial nominee programs, for example, Saskatchewan provincial nominee programs, where the applicants are asked for $75,000 good faith bond, and if the applicant doesn't comply with the condition, the $75,000 bond is forfeited. And my main concern is, if that kind of provision exists in those kind of programs, why not visitor visa cases, where we are losing a lot of revenues which we can generate from this industry. And the second scenario is the humanitarian ground. If, as I mentioned earlier, two cases where the family unification is important, in such cases, visa posts must make a decision based on their actual circumstances, like in case of Mrs. Kaur and Mr. Chui. The decision makers must empathize with the applicant and thoroughly investigate the reasons of the visit with due diligence. This would help avoid erroneous decision-making and unnecessary embarrassment to the authorities. In exceptional cases where visa officer is still not satisfied with the humanitarian ground, then visa officer may ask for good faith bond at applicant's disposal. And when the visitor they arrive in Canada, then CBSA, there is another option of CBSA monthly monitoring. If under this provision, if applicant arrive in Canada, at the port of entry, a visa officer may impose conditions such as monthly monitoring or attendance at the visa office in case if they find it is necessary for a particular case. The applicant may be imposed with the condition to inform and update CBSA about their stay and or intentions. In exceptional cases, they may hold their passport. They can hold foreign nationals' passport in that case. And then I have another practical solution for refused cases. The solution is appeal process. In a person when it's denied overseas.
Perhaps you could speed it up, sir. We're running out of time.
There must be an appeal process to challenge decision of a visa officer at designated visa post. The similar appeal process is available at the visa post level for UK and Australia. The current system allows an applicant to appeal in Federal Court of Canada, which is expensive and tedious process and is not in best interest of all the applicants. The appeal process will make the system more transparent and will avoid lineup of rejected applications at the federal court. The new appeal process must be posted on CIC's website to educate the applicant and will reflect the fairness of the Canadian immigration system. CIC may charge a nominal fee for this service for applicants who wish to appeal. And I would like to conclude with the following. The integrity of our immigration system can be maintained if the proposed changes are implemented so that every person is treated fairly and equally in immigration process. The implementations will help develop an efficient system which would prove to be a win-win situation for Canada and the applicant. This will help in growth of our economy by promoting multi-billion-dollar tourism industry, and for applicants to recognize the natural justice in the system. And if we don't act now, it will be too late to save our tourism industry, which can hamper our growth as a nation. For the visa post overseas, I would request that they analyze each application exclusively with an open mindset and provide a proper explanation for every rejected case. Since the visa officer has the ultimate authority in decision making, I would suggest that they be wise to use authority with greater responsibility and control.
Thank
you for giving me this opportunity today.
And thank you, Mr. Randev.